Brad Williams, Frugal Finance. Can debt collectors share my information? Can debt collectors tell other people you owe money? Most people assume debt is a private matter, but once collectors get involved, that privacy can feel uncertain. Picture this: your phone rings at work and it's about your debt. Now, imagine your coworker answers instead. Would they be told too much? That's where the law draws a hard line. Today, we're uncovering what debt collectors are actually allowed to say and what they're not. From family members to employers, the legal boundaries are surprisingly specific. If you've ever felt uncertain about what can be shared, this breakdown is for you. By the end, you'll know your rights, the limits collectors must follow, and how to protect your personal information with confidence. Let's set the record straight. The law behind the science. Under federal law, specifically the Fair Debt Collection Practice Act, debt collectors are not permitted to discuss your debt with just anyone. In fact, the only reason they can contact third parties like your family or employer is to ask for one thing: your current contact information. That's it. They're not supposed to mention the debt itself, the amount, or even hint at why they're calling. If they break that rule, they could be in violation of your consumer rights. This isn't just a technicality. It's a fundamental protection designed to keep your financial matters private. Violations aren't uncommon, but when you understand the law, you can spot them. So the next time a collector calls someone close to you, you'll know exactly where the boundaries lie, who they're really allowed to talk to. Here's the short list. Legally, a collector can only discuss your debt with you, your spouse, your attorney, or a court-appointed representative, like a guardian or executor. That's it. If you're a minor, they may talk with your parents, but that's where the door closes. Imagine if they tried explaining your debt situation to a nosy neighbor or your boss. Off limits. These rules are in place to shield you from embarrassment, misinformation, or pressure. Think of it as a legal cone of silence. Even if a collector accidentally reveals your debt to someone outside that list, it can constitute a serious breach. And if you're represented by an attorney, that collector better be speaking directly to them. No side conversation. The law is clear. Your debt is your business. Protecting your peace at work. Imagine trying to focus on your job, only to find out your employer received a call asking for you about a debt. Stressful? Right. Fortunately, collectors can't just call your workplace to discuss your obligations. They can only ask for your phone number, address, or office location, nothing more. And if the employer has a policy against personal calls, the moment you tell the collector they are legally prohibited from contacting you at work again, that one call should be the end of it. So, if the phone rings and someone else picks up, they shouldn't hear a single word about your financial situation. When in doubt, write it down, document who called, when and what was said. Your workplace should remain a stress-free zone. What to do when a third party gets a call. So, what happens if a collector contacts someone close to you, say a friend, a colleague, or a family member, and you're not sure what was said? First, speak with that person. Find out exactly what the collector shared, if any part of the conversation crossed a line. Mentioning a debt, stating that you're collecting, or pressuring the third party, that could be a violation. In most cases, a collector may only call someone once to confirm your location. Repeated contact, that's another red flag. If it happens, document everything, dates, time, who they spoke to, then file a complaint with the Consumer Financial Protection Bureau, or consider reaching out to a legal professional. Knowledge isn't just power here, it's your protection. Letters that talk back. You don't have to sit quietly while collectors push the limit. The CFPB offers a toolkit of letters that act like shields, each one drafted to handle a specific situation. Want them to stop calling? There's a letter for that. Need proof of the debt? Another letter's ready. It's like having a legal translator on standby. These templates are free, downloadable, and easy to personalize. They don't just express your rights, they exercise them. And when sent by certified mail, they leave a paper trail that says, I know what you're allowed to do, and I expect you to follow the rules. Think of it as setting the tone for respectful professional interaction on your terms. When collectors cross the line. So, what if the rules are broken? Maybe your employer was told something they shouldn't have heard, or a neighbor learned details about your debt. That's more than uncomfortable. It could be illegal. When collectors violate third-party disclosure rules, It opens the door to legal action. That's why tracking every interaction matters. Save voicemails, take notes, ask questions. You're not being dramatic, you're protecting your privacy. If violations are found, you may be entitled to financial damages, so don't hesitate to speak up or seek help. Consumer protection law exists for you. Stay observant and know that actions beat silence every time. You're not alone, and you're not powerless. At the end of the day, your debt is a financial detail, not a character flaw, and nobody has the right to weaponize it against you through gossip or shame. The law is on your side, and resources are within reach. Whether you take control through letter templates, legal advice, or simply knowing the rules, every step builds your confidence. Privacy is a right worth defending. So if a collector ever steps out of line, you won't just hope for fairness, you'll expect it. And that quiet strength, that's your real leverage. You've got this, and you don't have to go it alone. Brad Williams, Frugal Finance. Thanks for watching. Hope that helps. See you soon.